All good to go, everyone. We're good to go. Thank you. Kia ora, koutou. Thank you everyone for coming. Karakia Timatanga. I te Whakamutunga. I te Whakamutunga. Kia ora. Thank you very much, everyone. Welcome, John. Welcome back. Apologies, we have none. We're all present and accounted for. Conflicts of interest declaration, are there any? I don't think there would be. There being none. Public forum, there is none. Youth Council views, there is nothing. Forum, so straight into the first item of business, item 8, local water done well. Chief.
Kia ora, Your Worship. May I, with your permission, invite Catherine Newman, Project Director, to the table, who's joined with Emmon from Gully. They're here to answer all the difficult questions. So you'll recall, following our decision to join the Wairarapa Water Services Entity, we were instructed to go away and prepare the constitution and the shareholder agreement for the 4 councils to consider. So what we've been doing over the last couple of weeks is prepare the draft shareholder agreement and the shareholder agreement and the constitution for the proposed water services entity in conjunction with the other 3 councils and with feedback from the 2 mana whenua groups, Ngāti Kahungunu, sorry Joel, I'm looking at you, Ngāti Kahungunu and Rangatani o Wairarapa. Their feedback has, all feedback has been incorporated into the document, and Gully have been running point on preparing the document which you see in front of you today. We think that is a fair reflection of the term sheet that has been shared with council previously, and more than happy to walk through or talk through any of the issues you see with the 2 documents in front of you. Other than that, I'm happy to allow you to add anything I've missed.
It's a good summary. Yep. If it's helpful,
yep.
Emmon could talk a bit through around what is a constitution, what is a shareholders agreement, documents do, what how is your role as a shareholder reflected on these documents, and then happy to take any questions that you have.
Thank you.
Just before you jump in, Emmon, perhaps I could add that there is, we intend to create a 3rd document. So these 2 documents will deal with the company and the shareholders, and the 4 shareholders are limited under legislation to just being the 4 councils. So there will need to be a 3rd document, which is an agreement between the shareholders and whenua partners. So that document is yet to be created.
Well, maybe hi, I'm Emmon Nuns from Gully and have been helping all of the councils. So we're acting for all 4 councils to put together the documentation. The starting point for this has been the DIA have published forms of multi-council shareholders agreements and constitution. So we've based the documents on those. For the constitution, maybe I'll just point out the sort of departures from that. The constitution supplements the Companies Act and sets out the specific rules that your directors who are appointed will need to comply with. One thing we have done, because of them, to balance the 4 councils' interests, we've expanded the definition of independence. The Water Services Act stipulates that elected members and council employees cannot be directors of the CCO. We've expanded that out to a broader group of associates, effectively people who have had a material consulting role to councils, or in the last 2 years have been employees, including closest family members of those people, so that each of the councils can have comfort that the board is truly independent. There's not some external influence. So that's one key point. The other is that there is a 3-year term for your directors, and those directors can serve a maximum of 3 terms, giving a 9-year maximum, unless the stakeholders forum decides that there's a really good reason to carry on someone given their experience or whatever. So we don't want to rule someone out who's doing a good job, but the intention is to provide for turnover at some point after a reasonable period. So 3-year terms is what was settled on. So that's the sort of key constitution documents. The shareholders agreement is the other document. It's a private agreement between the councils, although the intention is that this document will be made publicly available in the interest of transparency. It doesn't need to be, but this sets out the agreements that the councils have as to how they're going to run their respective interests collectively. And the key point is that we've developed a stakeholders forum for which you will have a member and an alternate, and each will be other councils. So it will comprise 4 council members, with 1 appointed from each, and there'll be 2 members appointed by the iwi, 1 for each rangatane and 1 for Ngāti Kahungunu. So that will be a stakeholder forum comprising 6 people. The stakeholder forum will largely make all of the decisions that shareholders would make in the ordinary course of running a company on day-to-day things. So the appointment and removal of your directors will be undertaken by the stakeholder forum. The review of, or the preparation and review of the statement of expectations will be prepared by that stakeholder forum. But that statement of expectations, which is a document required by law, will ultimately come back to the council. It'll be a council-only decision, but the development, the preparation of that will be a joint exercise. The split then means council decisions are really for structural things. So changes, major transactions above $100 million in the term sheet would come back to individual councils for approval, as will changes in the capital structure, the business, and in particular, decisions around price harmonisation. That was ever to be proposed, which is contemplated for at least the first 9 years, there would be no price harmonisation. But at the end of that term, the board may put up a proposal around that, and it would be for councils to determine rather than the stakeholder forum. We envisage that you may, if you want to, delegate to your representative on the stakeholder forum or the council's decision-making, can act on behalf of the council. You do not have to delegate if you do not wish. That's up to the rules of the road for you to set for your member. But that member can speak on your behalf if you wish. I think those are probably the key things. There'll be various things the stakeholder forum will do, develop conflicts of interest policies. It will develop its own rules and procedures. The intention is that all of the councils will hold shares in this entity based upon their network connections, rather than, you can see it various ways, but the shareholdings are intended to be held based on the number of connections in the service area, so in your district. That's it. No, I'm happy to take any questions about that. I'd like to know more about the development.
The only other thing just to point out is I think in your paper, we've identified the issues that were in the term sheet that you previously signed off, and we've identified where those issues get picked up in the relevant documents. So it's just there as a reference.
Gully, have you been involved with preparing these sorts of things for other entities around the country?
Yes, we have.
And are you able to say that there's anything unusual about what's proposed here, or is it kind of,
I think,
part of the course?
No, I think part of the course is probably a good summary in the sense that although everyone is different, and the way that you approach particularly the stakeholder forum, the choices that you've sort of made about as 4 councils, what's important, but we don't see anything which is, I think that you've stayed within the requirements and also within what is contemplated by the published guidelines by Department of Interior Affairs. So we're consistent with that.
Other questions? While people are reflecting, I just asked for some comments around issuing of shares and the ability of the board to raise capital.
Yeah.
Please talk about those provisions because I would argue they're fundamentally important going forward, and I would also be hoping that should EB want to have more than just a sideline commentary capability as a stakeholder being given the privilege by the councils, that they would want to exercise a right to put skin in the game by fronting up with money.
Right.
And the only way they'd do that is to buy shares on a share distribution. Can you talk about that?
Yeah, absolutely. So I think the starting point is that you will receive your shareholding without payment. So there's no capital which has been put into this company from day one that the shareholders will be required to contribute. You are contributing on a ring fence basis. The assets and liability will be run for the district. The shares, though, will be based upon the water connections, and we reset that every 3 years. Now, in the event that the CCO was to recommend a transaction which needed shareholder money, they would need to come to each of the councils. And that would require your commitment to put money in, or you can't be required to subscribe for new shares. So major decisions are really going to need the commitment of all of the councils to build, or there is the ability to fund. The CCO could decide it wants to debt fund that. If it's outside of the LGFA funding, that the local government funding authority will provide funds, and there is a debt ceiling that you'll have, so you'll be limited in how much you can borrow. But if you're outside of that, it would need to be the shareholders. There could be private loans, including new capital could be sought from iwi if that was decided by the CCO. As the council, you couldn't direct that because that's an operational decision the CCO would make. But that is an option which is open, and it couldn't dilute your shareholding, though, because shareholdings are limited to councils.
Yes, please, Jeff, because I know it's an
Quite an interesting conversation about the initial funding for the entity and whether or not that initial funding was going to be through the issue of shares. So that this is the $5 million establishment cost, or whether we do that via loan. So and the conversation of new shares came up during that. And I think what was really important for us was the conversation around the entry of any new partner into the agreement can only be on terms that are no less attractive than what the original shareholders came in on. So I think that sort of joining up with the shareholder entry clauses around and making sure that any shareholder that comes in, whether they take it buy shares or whether they contribute asset, is on terms that are no less favourable than what the original shareholders came in. But I take the point that at this stage we kind of kicked the can down the road on how we calculate the value of that, because we didn't see it necessary on day one, because we could fund the establishment of the entity through debt and allow the entity to stand up on its own, and the assets and debt and revenues would be contributed. So we didn't really need to solve the price of new shares on day one.
And so that covers off both options of another TA wanting to pop out of their WSC because they suddenly don't like it. I'm thinking Upper Hutt, or I'm thinking Hawke's Bay, Central.
But you can't fire them.
or a private investor such as iwi deciding they want to have a stake in this.
That's right.
Yeah. Good.
All new council admissions will require a unanimous vote of your existing councils in order to approve that.
Yep. Excellent. Any other questions? Don't want to hold the floor. Ryan, your patch.
Yeah, I'm happy. Happy with this. I've read it a couple of times and yeah, got no real questions. So it's good.
Your general meeting? Or was it? Yes, Grace, thank you.
It's a question with regards to this. I've had meetings in the past with my concerns around the difference between this shareholder stakeholder relationship and how that interacts. I'm just reading on page, sorry, very small print. 55, where it's talking about replacing a stakeholder forum member, and it talks about how each shareholder appointed stakeholder forum member and alternative may be replaced from time to time by that shareholders providing written notice. So Carterton Council can get rid of our delegated person. How does this fit with the iwi when they don't have someone in the shareholder level to make decisions on the stakeholder representatives? Where's the accountability and where's the democratic process there to change people if there's issues? From a council perspective, we can interact with our person, but the iwi is separate, and I'm just not sure how this functions. Factually.
For the third
Piece of
document,
paper.
which is the agreement between the council shareholders
Yeah.
and the iwi stakeholders.
Mhm.
And we think that third document needs to walk through and articulate how those processes happen.
Mhm.
Yeah.
Right, in general terms, each council will appoint its nominated person on the forum.
Yeah.
And each iwi will appoint their nominated person via their own appointments process.
Yeah.
And then each organisation has the ability to remove and replace its delegate in the same way. So in the same way that Carterton could remove or replace its appointee, each iwi has the same ability to do that for it,
So,
only in relation to its own.
supplementary to that, knowing the dynamics between Taiwhenua and PSGE, where have you dropped down? Are we talking PSGE? Are we talking Taiwhenua? Or are we talking about, are we hoping that the four of them will separately by iwi come to an agreement as to who they're going to put up and what that mandate and what those terms of reference are going to look like? I mean, there's an agreement needed, I know, but this is a two-way street, and the councils are going to need assurances around stability and consistency of views being represented. We've seen too many occasions where someone who's not related to a particular hapu or an iwi has come in from the side, espoused a view. We had one on the golf course just recently. We've had one with the wastewater outlet that actually was the responsibility, the mana whenua were Te Kahukura Whitia, and they got blown off to one side through someone inappropriate being party to the decision making. How do the council shareholders get security and consistency and comfort over the iwi appointment?
I could answer that question.
Great.
So just right in the start, in the definitions of the shareholder agreement, we define Ngāti Kahungunu as the hapu Ngāti Kahungunu ki Wairarapa Tamaki Nui Aurua, as represented by Ngāti Kahungunu ki Wairarapa Tamaki Nui Aurua Settlement Trust.
Right.
So, and the same thing occurs in Rangatani.
Right.
We've defined exactly who we are talking about when we refer to Rangatani.
PSG.
Mhm.
Good.
And so just follow on. So in this subsequent document that we need to get together, would there be information in there regarding successions and timeframes and that kind of thing? Like we've got this a three-year term for the shareholder council. Would there be something equivalent?
No,
Make sure that there is that.
and Aaron will correct me when I stray, but normally what we would do is take this agreement between the four councils and copy that into a new agreement that it just expands the same agreement for six parties rather than four. We wouldn't want to try and create a whole lot of new terms and conditions and behaviours and all of that when we've already agreed to this is how we want to operate.
It's right. The letter arrangement or the side arrangement that we put in place with iwi, we based upon this. Your point about succession and turnover, I guess, of your stakeholder forum representatives is slightly different from the 3-year term, because the 3-year term is for the directors of the CCO.
Mm-hmm.
The stakeholders forum sort of sits between the CCO and the councils and has the iwi representation. And you can choose, you're not limited by a 3-year term. So you could have someone serving for 15 years, as could iwi. That is sort of their appointment right. The protections are, I guess, in the way that the decision making is made for that stakeholder forum. So broadly by majority, so majority for selected matters which relate to iwi. Primarily, that's the appointment and removal of directors. Other things are identified as being council-only decisions, and so the delineation between what decisions that council make, councils together, or the stakeholder forum as a whole, is set out in the schedule to this agreement.
Correct me if I'm wrong, it just seems like the shareholder forum has more of the power than the stakeholder forum. Sorry, flip that.
So there's only one forum.
Sorry, the shareholder, the board members seem very, you know, like, I'm just wondering if this is following on from Councillor Lawrence's question, if this is a standard sort of agreement that we're creating here, because it feels to me that the council, the actual shareholders don't have as much influence on what's going to be happening, and it's the stakeholders who have the majority of the say in how this is being run. And I just wonder if that's standard.
I think how would I describe that? The shareholders, the four councils, still retain the overall structural and important decision-making rights. That what you do as councils together through the stakeholder forum is have your representatives appoint the directors of the company that's going to conduct the operations. So that's the main thing that the stakeholder forum does. It's really an interface between the company and the shareholders, so that you've got a person who can speak on your behalf for making these types of decisions, and you don't have to go back and have Carterton or Masters and have full council meetings to get decisions made about the appointment of a director to the company. And this model is the one which has been proposed for multi-council forums. So it's sort of a shareholder forum, stakeholder forum in our case, because we're including iwi within that group. So I think the powers operationally sit with directors of the company. That's very standard. The middle level of the stakeholder forum is consistent with what's been promoted by the DIA as a way to have in this case, councils effectively coordinate their decision making. And so it's a coordination of decision making, really. But probably the point to stress is that you're not going to be making that many decisions, because this is really about every 3 years. Every year there'll be a director who's rolling off because we stagger them, so you'll rotate. Not everyone changes at the same time. So the 3-year terms, every year there'll be 1 or 2 appointments. But that will be the main decision that will be made each year by your forum members, as well as receiving and reviewing annual reports, asking questions, and they will all come to shareholders because they're shareholder rights. So I don't think this is a departure from what we see as normal good governance from a shareholder perspective.
It's also the process of developing the statement of expectations is a really important one that Stakeholders Forum does, and it is apart from the ability to appoint directors, that is your key point of influence on an ongoing basis as a shareholder, to make sure that the company has a view about what's important to you, and then they're required to give effect to that. So that's a really critical process, and one that as a group of shareholders, you want to make sure through that stakeholders forum that you're really active in making sure that the company understands what your expectations are for it. Because then legislatively it has to give effect to that, which is quite a high bar. It doesn't just sort of read it and go, oh, well, that's nice, I can sort of go and do my own thing. They actually legislatively have to give effect. So it's quite an important point of influence on an ongoing basis.
Any other questions? I'll just ask one more. Dividends, 9 to 12 years. Why 9 to 12 and not 9 like the harmonisation? What's the, I mean, some of us might have thought 9 to 12 years might have been good for harmonisation as well, but we just stuck with 9.
I guess the starting point for dividends is that you should not expect dividends. The requirement is effectively for
Well, hang on, if
CCO to
you
reinvest.
expect the cash call, you should expect the dividend.
Yes, well, I guess that's right to the extent, but ultimately the requirement is that there is reinvestment into the local water. So revenue which is used, which is raised, is to be reinvested into local water. So there has been a sort of decision that there will be a no dividend policy for a period. You can revisit that, and as shareholders, you can always look to change that if you see surplus cash available. But the expectation on setting that 9 to 12, there was no the alignment with the price harmonisation. The 9 years was just a proxy taken for a period of time which let this bed in. So 9 to 12 was within that sort of longer, sort of shorter, longer, medium, shorter, long term view.
I don't.
A few LTP cycles.
Exactly.
Probably the
Personally, I don't mind it because I wouldn't want anyone to have expectations that there would be dividends, given the size of the asset deficit here. But are there any other questions, comments, thoughts? Any councillor? Anything you want to close on, Jeff? Please?
No, I think this is relatively perfunctory. It's a reflection of the term sheet that council's been across a number of times. We've now got the legal detail behind it and the structure. I'm very happy that we're at this point. So thank you to both Catherine and Aaron and the teams behind them made this a possibility.
Yeah. Right then, ladies and gentlemen, move into the recommendations. They're all laid out, 1 to 6, and option 1 is recognised in recommendation 2. So, can we move to resolve? Someone care to move that we receive the report, and someone second it? Moved by the Deputy Mayor, seconded by Councillor Della. All in favour? Against? Motion is carried. So recommendation 2 approves the attached Constitution Shareholders Agreement for the Wairarapa Water Services Organisation. I shall move. Is there a seconder? Councillor Cherry Campbell. Thank you. All in favour? Against? One against. Councillor Aileen. Recorded. Thank you. Any abstentions? The motion is carried. Thank you. Can I be permitted to take, I'm just wondering if we could take all as one from 3 to 6. Is there any? Sorry? So moved by the Deputy Mayor. Recommendations 3 to 6 moved as one by the Deputy Mayor. And a seconder, please. Thank you, Councillor Lawrence. All in favour? Against? Councillor Aileen. Any abstentions? Wish to be recorded, Councillor Aileen?
Yeah.
Yes, record that vote against. The motions 3 to 6 are carried. Thank you.
Thank you.
Thank you very much, Councillor. Thank you very much. Sorry. Appreciate your time, Catherine. Thank you. That's right. And Aaron, thank you very much. Thank you. Moving straight forward.